they got that. It's interesting adjustment. Facilities are like, oh, just gotta get paid.
Good evening, and thank you for joining us today. It's the third night of our 6-week series, Celebrating Life, Understanding Death, brought to you by our Leon County Library and Leon County Senior Center. We hope those of you that attended the first 2 evenings have enjoyed it. The library has done a wonderful job and is now posted the first night's discussion, which was how different faith traditions view death. That was Candace McKibben that led a panel of different faith leaders. If you're interested in watching it again or watching it for the first time, all you need to go to the Leon County homepage and click on the YouTube channel, and you'll have access to it with subtitles. So, Leon County Library YouTube page. Thank you, Christina. So tonight's topic is starting the conversation, having a plan in place for your healthcare, your family, your pets, and your property, and getting your affairs in order. Tonight's speakers are Paul Malley, the president of Aging with Dignity, and he's going to help lead us to the 5 wishes documents. Definitely the best advanced directives document, I know. Planning for what matters most to you. Paul specializes in advanced care planning and patients' rights. Thank you very much for joining us, Paul. I'm so glad you're here today. Our second speaker is Ms. Candace Rudd, elder law attorney with Waldock and McConaughey in Tallahassee. Candace specializes in areas of guardianship, estate planning, public benefits, and advanced care planning. Thank you for being here, Candace. And we're thrilled to have you both. If you'd like to start the evening off, Paul, we're glad to have you.
Thank you very much. All right, technology is working. Everybody can hear, and we have a lot of folks joining us by Zoom too. So we have a nice gathering, a small gathering here, and a larger gathering extended with all of our friends in different places. Some I assume in Tallahassee, and maybe some that have family and friends elsewhere. But we're fortunate to live in a place that has a wonderful library and library services that are provided, and a wonderful senior center that provides great activities and events like this in different parts of the city. So good resources that are here in Tallahassee. And I'm going to speak with you, as Betty said, about one of those resources, the 5 wishes document. Candace is going to share from a legal perspective in the second part of the presentation. And while I have been grateful to work with a lot of attorneys throughout the years, and at Aging with Dignity, we worked with the American Bar Association, and they helped us to write 5 wishes. I am not an attorney, so it's a perfect lineup, a combination that I'm glad to have an attorney following so that she can give you all of that important information right after we talk about this more kind of a personal approach to starting advanced care planning conversations. My background is that I was drawn to the mission of Aging with Dignity, our nonprofit organization, because of my experience caring for my grandparents and watching my parents care for my grandparents. I was the youngest of 3 boys. There's 10 years between me and my 10 and 12 years between me and my 2 brothers. So I'm just mentioning that to say that as I was a young kid, my grandparents were already older. So by the time I was 6 or 7 years old, I saw them living with the challenges of aging, chronic illness. And my grandfather in particular was the first to really be seriously ill and in the hospital. And I remember one night the telephone ringing in the middle of the night, 3 o'clock in the morning. And I remember hearing my mom answer the phone. We had a pretty small house, so I could hear what was going on and across the hall. And it was a nurse at the other end of the phone. And she said to my mom, Mrs. Malley, your father's not doing very well tonight. We'd like to know what you want us to do if his heart stops. Would you want him to be resuscitated? Do you think he would want life support treatment? And even though my grandfather had been sick for a while, this was the first time this question was being asked at 3 o'clock in the morning. And think about how sharp you are at 3 o'clock in the morning, right? Not the best time of the day, not the easiest time in a crisis situation to really give thought to what the right thing to do is. And this nurse, she was well-intentioned. She was trying to do the right thing, but she said, we know this is a really big question and we want to give you time to think about it. But if you could please call us back in 10 minutes, we'd appreciate it. Wow. And what to do, right? I mean, she was thinking ahead from what was happening in the moment because she wanted to know an answer from a family. She was doing the right thing, but it was so much harder because our family had not thought about that. My mom had not thought about that. And I remember hearing the phone hang up. This is when phones actually hung up on a receiver. Heard the phone hung up, and my mom and my dad talked. She was sitting on the edge of her bed, kind of in tears, and saying to my dad, what do I do? Do I call my brother? Do I try to build family consensus? Do I just make this decision on my own and hope nobody's mad at me tomorrow morning? It was like the practical stuff that she was thinking through. And then the next day, it was actually a couple days later, when my grandfather's condition was getting worse, I was downstairs and I wasn't allowed to go upstairs because I was too young. This is when hospitals had more strict visitor requirements on the age, and I was below 14, I think was the age that you could go up to the ICU. And a nurse stuck her head around the corner in the lobby and she motioned to me. And she said, your grandfather wants to see you. And I got all excited because I was by myself in the lobby downstairs. So I walked with her. She snuck me up through the stairwell, so we didn't have to walk past the other nurse's station. And I walked into the room and I just sat on the edge of his bed with him. And he was talking with me. And I remember the smile that he got on his face when I walked in the room. And I remember thinking, I was 8 years old, I remember thinking I would do anything to help make my grandfather better, or to make it better for my grandfather, but I didn't know what to do. But just being present there, I knew how important that was. And I could see it in his face. And I was, thank God, because that nurse allowed me to, I was there with him when he died. He died with me sitting on the edge of his bed. And I just mentioned that because part of our work at Aging with Dignity is focused on answering some of the legal and the medical questions about thinking about some of these things ahead of time so that you're not stuck at 3 o'clock in the morning or in an emergency room waiting room thinking about this for the first time, or families having to second guess. But I also say it because part of what our focus is on helping you, every individual, every adult, be able to communicate to either family members or close friends or your doctors, the people who would be involved in your care, what's most important to you, including those personal things like just being present with somebody and what a difference that can make. Our organization, Aging with Dignity, was founded by a man named Jim Toohey, and Jim worked with Mother Teresa of Calcutta for 12 years. And the work of Aging with Dignity, with its focus on human dignity, and the work of 5 Wishes with its focus on what it means for somebody to feel like their dignity and their worth and their value is respected and protected. That's our approach to advanced care planning. That was a little bit different from kind of the boilerplate legal or clinical documents that had been around before. And I think that's why people responded to it. This is kind of like a little Tallahassee secret. Aging with Dignity and Five Wishes are based here. We've always been based in Tallahassee. We have an office on Capitol Circle across from Sam's Club. And Five Wishes is the most widely used advance directive in America. It's been distributed to 40 million people, all from Tallahassee, and it's available in 30 different languages. So what started here really became a model around the country. And I would say it's not because of what we did as a handful of people at Aging with Dignity. We're kind of like a little nonprofit organization that could, a handful of people that relies on the help of organizations all around the country, from hospices and employers and churches and libraries and senior centers and all of the above that provide Five Wishes to their communities. That's how Five Wishes has helped so many people. But what I'd like to do is just give you a nutshell description of what you would find in Five Wishes. Those who are here in the room have this document on the tables for you. And if you're listening to this by Zoom, the libraries here in Tallahassee are providing Five Wishes to you for free. You can walk into any of the branches and they're available. They're limited. So if you would like one, better to get it sooner rather than later. And you want to have one copy for each person who fills it out. So if you want to fill it out and you have a spouse, an adult child, a parent who you'd like them to fill it out too, you'd want to get one copy for each person to fill it out. In a nutshell, what it lets you do is name somebody who you trust to be your healthcare agent. This is in wish number one. It's called, instead of calling it a durable power of attorney for healthcare, which is what it is, the headline just says the person I want to make healthcare decisions for me when I can't make them for myself. And this is really important because this comes into play even if or even before you have a serious illness. This comes into play anytime you're not able to make your own medical decisions. If you're in a car accident, if you have, if you're recovering from having a hip replacement surgery and you're not of sound mind, you haven't regained your consciousness, your capacity to make decisions for yourself, then if a decision has to be made, your healthcare team will want to know, well, who do we talk to? And if you don't make a decision for yourself, if you haven't named somebody, then state law does the best that it can to have a pecking order of who would make decisions for you. Sometimes people don't realize that, but there is a pecking order. And if you haven't pointed to that person, and it's a family relationships, starting with spouse and adult children and on down the list. But it doesn't take into consideration how much communication you've had with that person, how close they are to you. It's just going by family relationship. That's an important thing, especially sometimes for young people to know if they have distance from their family of origin, if they don't have a spouse. Sometimes that can cause some big unexpected challenges in caring for somebody who's sick. So Five Wishes lets you pick that person to be your healthcare agent, give instruction about what powers you want them to have. And then Wish 2 lets you get into some specific guidance about life support treatment, when you would want it, when you don't want it. There's a definition there. There's a paragraph that says what life support treatment means to me. And it has a pretty broad definition of all the types of medical treatments that can be considered life support treatment in some situations. And if there's anything that you see there that you don't want to be considered life support treatment, there's blank lines below it, and you can limit the meaning of life support treatment if you'd like to do that. Or put any of your wishes in your own words. There are a few places in Five Wishes that all have blank lines, and sometimes people write, I mean it, with a big exclamation mark. And other times they might say, you know, I'd like you to try to come to family consensus if you can. Not naming multiple healthcare agents, but saying, I'd like you brothers and sisters to try to come to consensus if you can. And if not, here's the guidance that I'm providing to you. Those are some of the things that people might add into the blank lines and adding to it. So then Wishes 3, 4, and 5 are what I think really distinguish Five Wishes and have made it so popular, because these are the parts of Five Wishes that let you say the things that make you feel comfortable, the things that you want your family or your close friends or your healthcare providers to know, and how you want to be treated. For so many people, and there's national research that's asked this question, and most of the time the answers are pretty similar. when people are asked what's most important to you if you're near the end of life, people often say, I'd like to be at home if that's possible. I want my family or people who I love to be with me. Some might say I want to be prayed for or prayed with. I want to be comfortable. I don't want to be in pain. And many people will say, I don't want to receive medical treatment if it's not going to be helpful. That goes back to the life support treatment question. And many also just say, I still want to have a say in what happens to me, even if I can't speak for myself. And that's where all of 5 wishes comes in. It really becomes a record of your voice and what's important to you, even if you can't make your own decisions. And in wishes 3, 4, and 5, sometimes this is the easiest place to start. If you open up 5 wishes and you think, well, this looks like it would be helpful, but I'm not sure yet who I want to pick as my healthcare agent, and I'm not really sure exactly what I want in life support treatment, keep going. And sometimes wish 3 or wish 5 is the best place to start. Start with the place that feels most comfortable to you. Some of the topics in wish 3 about physical comfort are about pain management. And if you'd want to receive pain medication, even if that would mean that you might be drowsy or sleep more than you would otherwise. I saw one couple fill this out, and it was pretty interesting because they had been married for 50 years. And when they started, they said, I don't think we need to do this because we know each other better than anybody else on the planet. If I have to make a decision for my husband or my wife, I'll know what to do. And they got to this part, and the husband said, the most important thing to me is to be awake and aware and present with the family for as long as I can be. And I'd be willing to be in a little bit of pain if that meant that I had more time present with the family. And I looked at his wife, and she's shaking her head, and she said, are you nuts? If it hasn't been said, it's not going to get said. Give me whatever you got to give me. I don't want to be in pain. And they're kind of joking around with each other as they're talking about this, which is actually, that's great. And that's the beautiful part of 5 wishes, is that you don't have to get bogged down in some of the technical questions. You can make this more personal about the things that are most important to you. And in this conversation, in this couple's conversation, what came out was her biggest fear was being in pain. That was the thing that as she thought about what end of life might look like, she thought there were lots of things that she thought, okay, I'm okay with this, but I just don't want to be in pain. That came out as part of that conversation. And her husband was kind of surprised by it because they hadn't talked about it. But they wound up looking at each other and they said, well, okay, if that's what you want, that's what I'll do if I have to make a decision like that. That's gold, that bit of information. And those are the things that don't happen, the parts of conversation that don't just flow out of natural conversation on a given day. And that's part of the beauty of the 5 wishes format, is that it gives you something to guide through some of those discussions. There's some other things that are a little bit more focused on comfort, like I wish to be massaged with warm oils. And sometimes people laugh at that one. They're like, I didn't know we'd be talking about warm oils in an advanced directive. And I filled this, when I was filling this out with my mom, she got to this part and she kind of cringed a little bit. And I said, what made you cringe? And she said, I got a massage one time in my life and I couldn't stop laughing. I was so ticklish. I had to tell them to stop touching me. So she said, don't ever let anybody give me a massage. And I was like, okay, mental note, that's important. But I did say, well, how about a hand massage? Because my mom always liked to get manicures and like to have her nails done. And she said, oh, yeah, that'd be great. So hand massage, okay, nothing else. Definitely not a foot massage. She does not want anybody touching her feet. And my grandmother, I remember, she, speaking of feet, she always had hot feet. She wanted her toes to be untucked from the blanket at the end of the bed if she was in bed. And all the time, well-meaning providers would cozy her up tight with a blanket, tuck her feet in. And every time I'd walk into her room, I'd see her feet all tucked up because somebody thought enough to do that. And they thought that was what she wanted. But before I'd even go up and give her a hug, I'd just kind of untuck her toes and she got a big smile on her face. And those are the things that are also gold for families to be able to know that and to be able to provide it. By that point, I think I was like 10 or 11 years old. And again, I couldn't do anything or offer anything that was going to help my grandmother's health condition, but I could untuck her toes. And those are the types of things that 5 Wishes lets you communicate are important enough for you to mention it. And I just offer this, these are just examples that I know of even from my own family, but of people that I know as they filled it out, that they might have written things in the margins about, don't tuck my feet in too tight or tuck my toes out. Or I want to have music played and this is the music I want. This is the music I don't want. I do remember seeing one person's 5 wishes next to music and it said, please don't play any harps. I don't want harps. But everything else was fine. They just didn't want harps. And I want to be called by name is one of the points in there. It says, please call me. And then there's a blank line. And some people like to be called by their first name or Mr. So-and-so or Mrs. or Doctor, whatever the case might be. I remember my grandmother hated being called sweetie. She did not want to be called sweetie by nurses and doctors. She really, that was not a thing. She was not a fan of that. So this, again, it's a place to be able to communicate something that's important to you. And that's something like your name. And wish 5 wraps up with even more kind of relational types of topics, love and forgiveness, what you want your family to know, close friends, healthcare providers, what you want to happen after you've died, if you want a memorial service, who knows your burial wishes, those types of things. And then as you get to the back of 5 wishes, and to wrap it up, as you sign it, you want to make sure that you're signing it in the presence of 2 witnesses. And there's a list of exclusions there of people who can't be your witness. And that brings 5 wishes into compliance in almost all states, in 46 states. So Florida has some simpler witness requirements. And if you're filling it out in Florida, you can follow the rules in Florida, which are a little less restrictive. And Candace might have some guidance on that in her presentation. But if you follow these rules that are in 5 wishes, you've satisfied the requirements in now up to 46 states. And it's a legally valid advance directive that you should certainly give to your attorney. Talk with your attorney if you work with an attorney, and bring a copy to your doctor on your next visit. This is something that you do not want to fill out and keep a secret. Don't fill it out and tuck it in a file box or put it in a safe deposit box and think, okay, that's done and it's somewhere safe. If they can't find it until you're not here, it will not do you any good, right? So don't keep it a secret. Tell people you filled it out. You want to talk with your healthcare agent if you've named somebody in wish number 1, and make sure they're willing to serve as your healthcare agent, and that they understand what you want and that they're willing to stand up for you. And then when you go to your doctor, ask that a copy be included in your medical record, in your electronic medical record, so that it's there, hopefully, if you have a health emergency and your medical record is used. Having said that, I'll tell you what I do with my own parents, because we did those things, put it in the electronic medical record. When my mom was in the hospital, they couldn't find it. This is not in Tallahassee, but I don't think it's unique to the location. And so I talked with the social worker on the phone, and I had a PDF copy of her advance directive that I had in my email file, and I could just email it to the social worker. And in 30 seconds, she said, oh, great, I got it. So the bottom line is, I think it's great to put it in an electronic medical record, good to be a part of your health information, but I would also make sure that somebody who might need to know where to find it can put their hands on it, or has an electronic file that they can send to somebody really quickly. Just from my own perspective, a family perspective, you can't have too many people know about it. So in a nutshell, that is what I think are the benefits of 5 wishes. It's useful for all adults. You don't have to be a certain age to do it. We encourage everybody 18 and over to consider using 5 wishes, and to consider using it together, whether it's a family or a group of friends or neighbors, whatever the case is. It's not something that you have to feel like you have to do on your own. So with that, I'll turn it over to questions, and we'll be happy to answer any questions of anybody in the room or anyone who's watching virtually. We have a moderator who is keeping an eye on the Zoom chat. If you have a question, I think on Zoom, you can drop your question in the Zoom chat, and a moderator will help us know what question is there. And in the room, any questions? We like to keep it simple, so that's good. Yes, ma'am.
Do people usually write in this document? Do people usually write in this document all their things? Like, there's not a lot of space. Do they have addendums? Or?
Yes to both. So yes, people write in the document, in 5 wishes, people fill it out using the check marks and the blank lines. If you want to attach additional pages to it, you can do that. So in the blank lines, if there are things that you want to add, or in particular memorial service or funeral wishes, there's a very short amount of space for that. You can certainly add pages to it. And one of the other things that I think is important in Wish 5 is that there is a section there that asks for any other wishes that you want to convey. And one of the prompts that it encourages is the consideration of organ donation. So that's something that should be a part of this conversation as families talk together. And then it can be noted here in 5 wishes, and then also noted, depending on the state, but where it can be recorded. In Florida, that's often on our driver's licenses.
So a Zoom person asked, and this follows what you said, should the directive be filed someplace?
So the question is, should the directive be filed someplace? Certainly, you should give a copy to your doctor and make sure it's in your medical record. Make sure your family has a copy so that they can find it. If you work with an attorney, make sure that it's included as part of your legal paperwork. If you are working with an attorney on a estate plan, you certainly want to make sure to not fill out any other legal paperwork without including your attorney in that conversation. So it should be included in your file and talked about with your attorney. And you can fill out 5 wishes without guidance from a doctor, and you don't have to have an attorney to fill it out. But in all those places where important papers would be looked for, you want to make sure you have a copy of 5 wishes. You don't have to give it back to us. We don't record it. We don't hold on to it. We're not a storage, electronic storage or otherwise. So the best thing is to just think of who would be looking for it and make sure they don't have to look hard to find it. And don't keep it a secret. Another Zoom question.
Yes. What are the 4 states that do not accept 5 wishes?
Question is, what are the 4 states that do not accept 5 wishes? There are 4 states that have mandatory form requirements. So they say in these states, you need to use statutory language that's specific to Texas, Ohio, Kansas, and New Hampshire. Those are the 4 states that have specific requirements. When we worked with the American Bar Association, as you can imagine, this was a pretty hefty task to look at all 50 state statutes for advanced directives and look at language that was required and what satisfied what parts of law of each state. So 5 wishes on its own meets the legal requirements in the 46 states except for those 4, Texas, Ohio, Kansas, New Hampshire. And even in those states, if you have family members who live there, they can still use 5 wishes and then either combine it with their state form and put the 2 together. But they want to make sure that the legal bases are covered in using the required language in those 4 states that have extra requirements. Any other questions? Very good. Well, thank you very much for the attention. And 2 things I'll leave you with is the reminder to make sure you get a copy of 5 wishes for yourself and anyone who you know who could benefit from it. You have a great gift now of receiving this information. And the best way to bring up the conversation with somebody else is by talking about some of your own wishes first. So rather than putting them on the spot and saying, hey, I went to a presentation, I thought you would really want this. You kind of break the ice a little bit by talking about the fact that you've given this some thought. And if it's a family member or somebody close to you who you want to know what you've decided, you can use that as a door opener. Start with explaining to them what you thought about, what you want them to know about your decisions, and then you can bring out the second copy and encourage them to fill it out for themselves. And so after you have your copy of 5 wishes that you pick up from the library, if you have any questions, on the back of every 5 wishes, there's contact information for our office, and you're welcome to contact us. There's a toll-free number, 1-888-5-WISHES, that's on the back cover. And because we all share the same hometown, if you even want to come by our office, if you have any questions, happy to help you with answering any of those or to provide more 5 wishes to you. So thank you very much.
Thank you so much. Thank you so much, Paul, and remember that you can pick these up at any of your library branches. One of the things I love most is that this is written in plain English. It covers medical information, but it doesn't have medical terminology, and it is a legal document, but it's not written in the whole legal term.
Thanks.
So, yeah, this is why we have people like Candace Rudd. But, so please, thank you to the library for providing these to us. Thank you.
Thank you, ma'am. And thank you for coming. My name is Candace Rudd. I'm an attorney at Waldock and McConaughey, specialize in elder law. Before I became an attorney, I was actually a social worker. So I have a very different background, which means I kind of talk and approach clients a little differently also. Thank you to the libraries and to the senior center for inviting me. I appreciate that. And for Paul for giving you a great explanation of 5 wishes that I hope I don't cause more confusion for you, as attorneys tend to do, but I have to keep a job. So confusion is my game. So when you come to an attorney to discuss estate planning, there's going to be some basic documents we're going to want to review with you. The most important is durable power of attorney, healthcare surrogate designation, living will, and a last will and testament. Some people also include trust and other work deed things into that. But those 4 are the main ones we want everyone to come talk to an attorney and get done. Whether you're 18 or 111, you have to get them done. So kind of go through each one. You're going to get the super Cliff Notes condensed version of them. Now, if you do speak to an attorney, you're going to get a much more in-depth version that applies to you, your documents, what they say, your situation. So power of attorney, that is the most important document in my opinion. So on power of attorney, you are the principal, you're the one executing the document, you name an agent. The agent is a fiduciary who's going to act on your behalf in financial, legal, contractual matters, kind of very broad. But the most important thing to know is when you sign that document, it becomes effective. So the agent you have named can go out in the world and do things for you for your benefit at that moment. So most people think that they have to wait till they're incapacitated, then that person goes out and asks for them. No. So if I sign a power of attorney, it names my husband. If he needs to sell our house, he can sign it, sign my name, go on. So as long as it's for my benefit. If you do something that's not for the principal's benefit, you violated fiduciary duty and you're subject to civil suit. So there's that balance, but know that that authority is immediate and it's large. The main ways that I use powers of attorney is when people are transitioning in care. So they need access to financial accounts to pay bills. They need to sign contracts for assisted livings or skilled facilities. They need to rearrange assets to become eligible for Medicaid. All of those things require a power of attorney, even if you're married. So your spouse isn't guaranteed those rights just because of marriage. You still have to sign that document giving that authority to them. The execution requirements for power of attorney are very specific in Florida. So inside the document has to have very specific statutory references for authority, has to be signed in front of 2 witnesses and a notary before it's effective. And the principal must have contractual capacity, which means when I talk to somebody, I have to make sure they understand the nature and business being transacted in the document, that they understand the authority granted in the document and how to revoke that authority. If you can't understand those things, I'm not going to let you sign it. So know that there is a bar, and some of my clients don't meet that. Unfortunately, they just come to me a little too late. The next one is healthcare surrogate. So just like he was talking about that first wish, we do the legal version of that, which is going to be a lot more legalese terms. But basically, it names the person you want to make your healthcare decisions for you if you are no longer able to do so. That means a medical capacity determination, which is different from a legal capacity determination. Our document specifically has some different levels of authority. So you can actually say, I want my surrogate to be able to access my healthcare information now, talk to my doctors now, and help me make decisions now. So that really works well for spouses and children, adult children, when they are taking that loved one to appointments and they're engaged in that conversation actively, so that that whole time they're having that HIPAA waiver, they can have full access to everything that's going on. They can go pick up blood work, they can pick up x-rays, they can go to the hospital and talk to the doctors. There's not that determination of capacity before your authority kicks in. So it's a little more flexible in that front. Our document includes all different kinds of levels of information and authority. So it says you have to work with a guardian if the one's appointed. You could be overruled by the court and that document thrown out. Medical marijuana has become kind of the leading front in Florida. So ours has specific authorization allowing your surrogate to obtain that prescription and order for you if necessary. So that's kind of like a legal gray area in some places. If you're not the initial individual, how much authority do you have? We're just going ahead and granting that to you to make sure that you can do that. Inside of our healthcare surrogate is the living will. So the living will is the most important discussion that we have, and usually a discussion no one wants to have with me. That document basically guides your surrogate. Once you hit a certain point, what kind of life prolonging procedures do you want? How our document is written under Florida statute says that if you are end stage, persistent vegetative state, are terminally ill, that's box 1 you have to check, and you've been declared incapacitated by your attending physician and a second physician. So both of those elements have to happen before your living will can even kick in. And it says, I want my surrogate to withhold life prolonging procedures from me so that I can die naturally and comfortably. Our document has them listed out and very detailed. So we want clients to go through that with us and see what are they comfortable with. Do you want to be tube fed? Do you want IVs? Do you want surgery? Do you want x-rays? Do you want nothing? So it's going to be very specific to each client. One of the important things we know from COVID is people got to see what an ICU looked like. Most of us never saw the inside of one. We haven't seen people hooked up to ventilators and what all that treatment looks like. And now clients are saying, oh, that's what they're going to do to me. Yeah, at 92, that's what they're going to do to you. And so it's important to know, are you comfortable with that? And that's something we all have to decide for ourselves. Generally, I like my clients to take that home, read it a few weeks, get back to me. If they're comfortable with everything, we leave it. If they want to strike something out, pull it out. Your document, completely editable. It's been a long day. I can write it however you want. That's what you pay me for. So we can tailor it to you. For example, I have clients who their religious practices forbid them from taking blood. So I take that and I push that all into our document. It adds another 2 pages, but it's very detailed. I don't want blood products. I don't want plasma products. I don't want this. I don't want that. So that way it conforms to their religious practices. So we can do anything that you need. Know that. And that is also kind of contractual capacity. It's a little more, when you sign that one, it's not quite as hard as power of attorney because the business being transacted isn't as legal. As power of attorney, I'm like asking you, can they do a trust? Can they gift for you for exemptions of taxes? Those things are a little more difficult to understand naturally. The last document, a will. Basically what a will does is it's the disposition of your property at death, meaning that document has no effect while you're living. It only becomes empowered once the court admits it to probate. So before then, it's just a document outlining your wishes and your desires for your property. And it can be as specific or as broad as you want. So you can say, I'm going to make this list of my tangible personal property, meaning your movable items and goods, like things in your home, your car, stuff you can pick up and tote away that's not cash. Tangible personal property, and you can detail list. I want my duck figurines to go to Janice. I want my ceramic cat to go to mom. You can get as nitty gritty as you want, and that attaches to your will. We can specifically divide your homestead. We can create trust for people in your will. So if you have a child or a sibling or someone you want to give things to that is either disabled, that can inherit because it's going to cause them to lose their public benefits, or they have some kind of issue, they might have a drug problem, a drinking problem, gambling problem, just overwhelmed problem. They need to have a trust to protect them. We can build that into your will and help guide that property so it's protected. The capacity to execute a will is a lot different. It's called testamentary capacity. So you have to know who you are, most importantly. You got to know who your family is and what your property is, how you want that divided. So that bar is much lower than a contractual capacity. So some people may be able to execute a will, but not a power of attorney. And that's what an attorney does. Do you understand what we're talking about? Can you actively engage in that conversation and execute these documents? And a will in Florida, to be properly executed, must be signed at the bottom. It's specifically says at the bottom in statute, has to be signed by 2 attesting witnesses. So 2 people that watch you sign, you watch them sign, everybody signs together. And it can be self-proved with a notary affidavit. So I'm kind of a nerd. I mean, I'm a lawyer, who would have guessed? Hold on a second. So there's actually like court records out there where they discuss what does it mean to be in the presence of each other. Do you have to be in the same room? Do you have to be on the other side of a window? Can you do it in one person's in the car, 2 people are outside the car? So, you know, you get down the legal rabbit hole of what is in the presence. That's why, you know, if you're in an attorney's office, hopefully you're executing it properly. Everyone's together in the same room. We're good to go. Something that's kind of interesting that we don't have yet in Florida is called PULSE. So physician orders on life-sustaining treatment. It's been in legislature multiple times, but what it is, it's like a living will and 5 wishes. It's ramped up and it comes directly from the doctor. So that might be something we have discussions in the next 2 to 3 years, 5 years about. It talks about, you know, CPR, like a DNR. It talks about, you know, the goals of medical treatment. You want to be transported to the hospital after to a certain point in your disease. You know, do you want to be tube fed? So these are important discussions that will be in a legal document, sort of, but it's really a physician order. So something that you and your primary would discuss in-depthly. Ideally, it's going to be like 5 to 10 pages long anywhere. There's National Pulse that's out there. You can look at those, but it is something to think about and keep an eye on and watch in legislature. If, you know, if you're kind of nerdy like us, you like to know those things. You know, once you have all these documents, we give you a folder that everything's in together. So it's really easy to keep track of it. We give you copies, we give you a digital PDF. I always tell my clients, take it home, put it somewhere safe in your home that at least one other person has full access to. So, you know, if you have a safe at home, that's where you like to keep everything fireproof, great. Who's gonna have the code to it? Because we don't want you to become incapacitated. Nobody know you don't have documents. And then you end up in guardianship court where you're paying an attorney to represent you, paying an attorney to represent your petitioner or potential guardian. You're paying court costs, paying examining committee costs. You're spending $5,000 to $7,000 because no one can find your documents or you don't have any documents. And what happens in guardianship is the court strips you of your rights. So based on incapacity determination. And it's all done in open court. So if you're sitting there and you have advanced dementia, but that day you're having slightly a clear day, you get to hear all your kids and the doctors and 2 social workers talk about how incapacitated and incapable you are caring for yourself. So it's really charged, it's really emotional. It's not something that I like to do. But when you get to that point, that's the only way to protect somebody. It has to happen. So the best thing to do is be prepared and avoid that altogether. Because nobody wants that experience, for one, and 2, nobody wants the court involved in every life decision that's going to be made for them going forward. So, any questions? I know I go kind of fast, but I don't think you want to just hear me lecture you about what legal stuff is. Yeah. Hold on just a second. She's going to grab the thing for you.
What thing?
The microphone.
Oh, the microphone. Oh, wow. I don't want to be on the spotlight.
Would you like to ask a question?
Yeah, I'm gonna ask a question. Hi, my name is Doug. I have a special needs trust. I'm not sure what type it is. My aunt had put $290,000 in a trust and I'm homeless. Every time I ask for something, they just deny it. Is there a way I could reverse the court's decision and let the judge know what's going on? So they could change.
When you can't afford an attorney, the best option is to go to Legal Services of North Florida and they will connect you with somebody that specializes in that type of work. I don't do litigation.
The Florida bar?
Yeah, so then I don't do litigation, so that's what that would be. That'd be a litigated item. But, and then you can also appear pro se. You just go through the clerk of the court to file documents.
So it can be done?
In theory, I don't do litigation though. So that's the caveat. Not my practice area. Did you have a question, sir?
Yeah.
Hold on just a second. She's gonna come to you.
They can't hear us.
Oh, well, okay. Is there a relationship between the power of attorney and the personal representative that is specified in a will?
So it can be the same person, but the biggest distinct difference is agent under a power of attorney has authority while you're alive. At your death, that power ceases immediately. Then the personal representative only has power and authority once appointed through the court system in the probate. So there's going to be a gap for everybody regardless. It just takes time to get into the court system. But so say I'm acting as agent for someone and I'm paying their bills, they pass away, that bank account's going to be immediately frozen and I will have no more authority to act on their behalf. Does that answer your question?
Another very quick one.
Sure.
In Florida, is there a statute of limitations applying to probate?
So in what context? Like how long you have to file it, how long creditors have?
I know about how long the process have. How long does a person have to file regarding
Opening a probate?
no, corrupt attorneys and people. There are a lot of them. Yeah, exactly. I was going through a total nightmare. I'm in Tallahassee as a result of probate. Very quickly, my aunt, who never got married and never had any children, considered me to be the closest thing she ever had to a child. And unfortunately.
So if you're talking about like opposing or litigating in a probate, that all depends on whether it's testate, intestate, and notification requirements. So it really is specific to that case. If you have a will, you only have 3 months to object to the will if you're properly notified. If you don't object in that time period, the time period changes. But essentially at the order of discharge for a personal representative, everyone's cut off to all litigation period at that point. It's considered finalized. So it's very detailed oriented, and I'll give you the answer my husband hates. It depends on your situation. He said, if I say it depends one more time, he's gonna leave me. We have a Zoom question.
We have 3 questions.
Okay.
Is real estate passed to heirs in the will if they're not named on the deed?
Yes, so if there is no pre-existing deed, like a ladybird deed, what's called an enhanced life estate deed or life estate deed or a full-fledged deeding away of the property, it would pass through the probate system, either intestate, meaning you pass without a will, or testate under the terms of your will. So you can specifically devise property, say I give my homestead to child A, or you can just say what's called a residue or remainder. I give all my remaining property, not specifically devised, to my children, so that it would go to all of your children. So it just kind of, it depends.
Right, I do not have an attorney. How do I find an attorney that can take care of these details? Is it expensive?
So the Florida bar can do an attorney referral service. So it depends where you are and what you're looking for. If you're looking for local attorneys, you can look up elder law board certified attorneys. There's only a handful. Jana McConaughey at my office and Lachlan Waldock, both are board certified. You have to be in practice for 5 years, so I'm almost there to be able to take the test. So that's a great way to start. Also, referrals from friends and family are professionals. Ask a doctor, ask people at the senior center. You can call legal services in North Florida. So there's ways to access an attorney. Cost is very specific to each attorney. So everyone's cost is going to range depending on their practice type and the client's assets that are available. So, obviously we're not going to charge somebody $3,000 when all they have is a house and a bank account with $2,000. That's just not, not going to happen in my practice. I can't speak to anybody else's.
One more question. You might have mentioned this, but what happens when someone dies and they have nothing set up?
So if you die without a will, that's called intestate. And what that means is it passes by Florida statute. So it's the order of people who would inherit from you. If you're married, it's your spouse first. If you're not married, and you have children or your spouse has predeceased you, it goes down. So if one child has died, then it goes to their children. So it's kind of like a little tree branch all the way down. The dangerous thing about that is if one of them is a minor and they inherit more than $15,000, now that minor needs a guardianship, which is expensive. I have two crazy cases right now where a will was written, but it was old, didn't have a residue. So some of the property passed by the will. The residue had to pass by intestate. So she had 8 siblings who had all predeceased her. So then it was their children, some of them had predeceased, and then some of them had predeceased. So we're all the way down here. And some people get 1/72 of a fraction of the estate. And now I have one where a man had no children, so it would go up. So if you can't go down, you go up. So his parents are deceased, so then it goes to his siblings who are deceased, so now it goes to their children and then their deceased children. So you get these fun little maps and fractions, and lawyers doing math is probably never the best thing. So best thing is to have the will done yourself. Most importantly, don't write and sign one yourself. That's called a holographic will. Those are specifically disallowed in Florida statute. They are allowed in Texas. Texas has weird laws. You can write your own. I'm from Texas, so I can talk about it. I'm not an attorney, so I can't give you a legal opinion, but you can write your own will and sign it. That's fine. But a power of attorney to healthcare surrogate has to be this exact form from statute. Otherwise, it's garbage. Weirdest thing. I don't understand my home state sometimes. One more.
This is kind of hard, so. bear
Okay.
with me. If a person owns interest in an LLC, would that interest automatically transfer to your children who are listed in the will? Or must the partnership transfer preferences be explicitly stated in the will?
So it depends on your LLC agreement, how the membership ownership interest is divided and passes at death. So if your LLC specifically speaks to that, it would, like, some people devise an LLC that says if a partner were to pass away, that percentage of the ownership goes to the other partners in equal shares or whatever it might be. If there is no article like that, then it does go to probate. I just assigned LLC membership to 2 minors, 3 months ago, 6 months ago. So it happens. No one's happy when that happens because now an LLC has surprise members that they weren't planning on, that they have to take into consideration on all decisions and sales of property. Not the best situation. That's why you should also get an attorney to write your LLC. One thing you'll figure out is if you don't get an attorney to do your legal documentation, you're going to pay an attorney 3 times as more to fix the legal documentation. You should have had that in the first place. I fixed so many online powers of attorney that are just garbage that do nothing. And when I can't fix them, I end up in guardianship court where we're paying thousands of dollars to fix a mistake. Because they're advertised as Florida compliant, but they're not. Florida, like I said, has very specific statute references that have to be in these powers of attorney. So if you want to do investment or you want to do banking, you have to specifically reference a statute that grants that authority. And we have something called specific enumerated authorities. So to be able to do these certain activities, you have to specifically sign next to each one. If you sign at the bottom of all of them, that's invalid. If they're combined, that's invalid. So it's very detailed and specific. So you want to be with an attorney that understands estate planning nuance and keeps up on law. You had a question, ma'am, and then I'll get back to you.
And you may have just hit on it.
That's okay.
I'm not sure. So I did the living will that was through the mail
Mm-hmm.
and given everything to my kids and
You did a last will and
No.
testament?
I guess that thing that was in the mail a while back.
I have no idea.
Notarized and witnessed. Am I being naive to think I'm finished with everything?
So it would depend. If it's like just a last will and testament that says I give this and this and this, you've probably hit the elements if you witnessed it in front of 2 people and notarized it.
Well, I just said 3 kids.
Yeah.
Divvy it up.
The dangerous part about that is if you didn't have a proper residue in that will, so residuary clause, if you didn't give specific authorities to the power of attorney that they might need. So it's really important now that we have like digital asset authority outlined, our investment authorities, or the ability to sell property. If you had 2 or more PRs named, do they have to be and sign everything, or do one have authority? So, I don't know what you're trying to do to make your document work the best for you. But no, if you just named all 3 of your kids, default in statute would be your 3 kids. So it's not gonna, if your will fails, it's not the worst thing that can happen to you. What,
So it is kind of the end of the story?
do you have your other documents done? Because that's not the end of the story.
Depends.
Because if you don't have a power of attorney and your healthcare surrogate, you still
I
need
have this document done and that.
Power of
And the
attorney.
stories?
No.
No.
durable power of attorney.
Okay.
Yeah. And usually like what we do is we package them. So we do like a flat rate fee for the documents. You know, some attorneys do hourly rates. We find it easier just to do flat fees. It's more convenient for us. You understand what you're getting, the value of it. Also, I don't want to track my hours constantly for every single case I do, because that's kind of horrible.
Thank you.
All right, my question is, all right, when my father passed away, he had Alzheimer's disease. My aunt had went down to California, originally I'm from the Bay Area, Silicon Valley, and what happened was my aunt showed me a briefcase that my dad kept all his important documents. She showed it to me in the living room when I first moved down from California. It was pried open. They said there was no will. So how do I know if there is? And my dad did make a will. I'm sure he's Air Force 35 years, so he was very organized.
I would have no idea.
Is there a way to find out?
So there's no will registry in
They said
Florida.
there was no will for my dad when he passed.
Yeah, and
Which was
that's,
kind of odd.
it's not uncommon. So so in Florida, you can write a will and then you can, you know, tear up your will. You can mark through it. You can shred it. All those things say I revoke it. You can just tell people you revoke it in writing. You know, I revoke the will, da, 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 da. So there's multiple ways to do that. So some people do end up doing that at the end of their life. Some people change it at the end of their life. That's one of the important reasons to make sure that they're talking to an attorney, that they have the capacity to change that. Because we don't want them, you know, we don't want a caregiver saying, hey, you should leave me your house, driving them to an attorney's office or driving them to, you know, to the bank. Here, sign this, you know, we don't want those kinds of things happening.
There's 2 parts to my question. And then also, there was a house that my aunt said that was a joint house with my dad had died and sister, which I don't believe. My aunt's well off. I don't know how her name, how she got ownership of the house. She didn't be on my brother.
That would depend on the deed. So that,
Can we find out?
yeah, that's in the official records. So you go to the county clerk's office and they'll pull deeds for you.
How much is that?
It's free.
Oh,
I mean, to look it up is free. To print it, I don't know if that's a clerk fee. Yeah, our official records are online. So you can access it through the clerk's website. Yes, ma'am.
One more question from our Zoom. My mother had a right to die, but when she choked and lost consciousness, they put her on life support and her body was hurled up and down in the bed. The doctors at the hospital said they had to keep her on life support in spite of the document. She was 95. Why did the doctor say and do that?
Can't answer for her specific instance, but I can tell you that a doctor, hospital, EMTs, they do not have to honor your living will if they don't know it exists. So if they never saw a copy of it, they can't verify that's what you wanted, and their duty is to keep you alive. I had one client who was in a nursing facility. I'd executed his documents. His son never provided the documents to the nursing facility. He had a massive stroke. They intubated him, put him in ICU on life support for 3 days, and the son had to go to the hospital and have everything removed. So the son and the father both experienced this very traumatic event because of lack of due diligence. And, you know, unfortunately it happens. Usually with your healthcare documents, one suggestion is to keep them in the glove compartment of your car so they're easily accessible. If you are under hospice care, usually they provide you, if you've signed a PNR, a laminated version that they keep on either the end of the medical bed or on the refrigerator. We say, go ahead and put your other documents attached to that, so it's all together. What I personally do, because I am my grandmother's agent, I keep her copies in my car, so if anything ever happens to her, I can pull them out and I'm right there with her no matter what. You know, her physician has a copy. I have digital copies on my phone, like, so it's always accessible to me because I'm the person who would be responsible for it. You don't want to necessarily put the person who's sick and dying, the one who's got to be responsible. I mean, they've got to be responsible for enough.
So I have a question.
Oh.
Can you talk a little bit about, and we are out of time, sorry.
It's okay.
Can you talk about creating a net for if you have an adult dependent, if you're, have an adult child that needs.
Talking about creating a special needs trust for them?
Yes, or pets, or, yeah.
So that can happen either in a standalone trust or in your will. So we create pet trust all the time. We also create special needs trust. So when it's inside your will, it's called a testamentary trust. If it's standalone, it's a first party standalone trust. Some people still do it for your pets. It's not as popular as it was. It is much more popular down in Ocala where people have large horse farms and those animals are worth hundreds of thousands of dollars. So they need trust to protect those animals and the lineages associated with them and the care. And some people do it for their cats. So it's just kind of, what are your assets? How do you want to divide those? Do you have the financial means to support a trust? Because sometimes the trust will pay out before anything else pays out. So you might have divested everybody in favor of your pug. So that has to be an honest conversation. Like, do you want your children not to have anything, for your neighbor to run a trust for your pug? It's up to you. For children with special needs, whether they're minors or adults, you absolutely have to have a special needs trust for them if they're going to inherit from you. Because if they inherit outright, first they lose their benefits potentially because they've just gained assets over the limits, whether they're on SSI or Medicaid or whatever it might be. Two, if they have to set up a trust called a first party special needs trust with the funds they inherited, those require a payback to the government for all the benefits that they've received. So that money can't pass down to their children or to whoever, it has to go back to the state. Versus if it comes to a third party trust, that money can be directed after their death to whoever you want. So it's very important that that's set up correctly. So, some people don't mind paying the government that, that's fine. We're cool, we can pay the government all you want, but some people are really opposed to that. So we want to make sure that you're very aware. Did you have another one or are you good? Okay. I put my cards on that table over there for people who are here. You're welcome to take one. So if you need anything.
Thank you so much, Candace. Clearly, people had a lot of questions about that. And thank you so much, Paul. I think the most important thing is to know that it makes an enormous difference to your family if you have your affairs in order, for them to help them make those decisions if they need to, and to also have things in order so it's not a huge legal mess after. But I think most importantly, in getting to meet you both, for a lot of these people, is to know that there's wonderful people out there like this that are well trained, that know what they're talking about and they want to help you. And so know that you can reach out to them or people like them and ask these questions. I know Candace mentioned she's trying to teach in this kind of general term, but everyone's situation is so unique. And so please, if you have these questions, find those attorneys and get your things in order. And the other thing I forgot to mention in the beginning is we have our evaluations. So those of you that are in the building, if you could please complete the evaluation. And if you're on Zoom, if you could please do that for us, we'd really appreciate it. And thank you for joining us. We'll see you next week. Next week is on grief and loss, and we'd really like you to join us for that. So thank you all, and thank you, Christina. Thank you, Maria. Bye-bye.
Can I watch the Zoom meeting?